Well, good afternoon, everybody, and welcome to what I think is the last King's Chambers Costs Seminar of 2024. Already it's getting dark outside. Christmas is just round the corner, but what better way to end our series this year by a chat about retainers. So joining me tonight is Matthew Smith, and we're going to go through quite a number of points which relate to retainers. And we've already had a number of questions sent in by people who've got particular points that they would like us to cover. So in broad terms, what we're going to look at tonight are some general themes. We're going to look at perhaps the most common forms of retainer in the terms of non-contentious business agreements, conditional fee agreements, of course, damages-based agreements, the curious position of litigation funding agreements, many of which have now been roped into being damages-based agreements, and look at some practical points about the solicitor's accounts rules, which often people haven't looked at since they did the LPC, and some current issues in drafting. But if we sort of start by way of overview, I think one of the themes that struck both Matthew and I when we were looking at this topic was that if you're looking at a sort of general direction of travel in relation to retainers and what sort of approach the courts are taking to them, it might be that there's now very clearly a philosophy of consumer protection applied to the drafting and use of retainers. What I mean by that is that although a retainer will often be drafted by a solicitor for use with a client, it's not going to be possible, was never possible, to load it up so that the client was actually sewn up by disadvantageous terms. And if that was ever thought by anyone to be the case, then I think only by looking at just the most recent case law, one can see that that is certainly not the case, the approach the courts will adopt. So one of the cases that caught my eye this year was a case called Glazer and Attay, which is a decision of the Court of Appeal. And I think it illustrates the point quite neatly. In that case, we had a situation where barristers were acting for a lay client on the basis of a direct access arrangement. What they did was what barristers often do, which is provide for the fees that they were paid for the work, in this case a substantial hearing, to be paid up front. But there was no provision in the agreement that they made with their clients that if the hearing proved to be non-effective, came out the list, was adjourned or anything like that, for anything other than the full fee to be payable. And when that did in fact happen, listing being what it is, the client complained about the fact that they had, as they saw it, had nothing for their money, and of course sought their money back. And in the High Court, effectively the High Court judge, Mr. Justice Turner, struck down what were the offending clauses of the agreement using the Consumer Rights Act of 2015. That decision went on appeal to the Court of Appeal, and the decision of the High Court was then upheld by the Court of Appeal. And so one can see here quite graphically consumer protection legislation being invoked in the area of lawyers' retainers to effectively protect the interests of the client, where the court takes the view that the balance of the agreement is tilted far too heavily in favour of the lawyers rather than the clients. So that's, I think, the opening theme that I would give you. And Matthew, what do you think about this direction of travel?
I entirely agree. And knowing what my concentration span is like, I like to get the most important points in first. And if you remember only 3 things from this talk, then I think you will have done yourselves and indeed all of us a service. They are these. Number 1, these are general themes. You need always to think about consumer protection, because whether the client is right or whether the client is wrong, a disgruntled client will always, and especially if they seek professional advice, seek to argue that a certain clause in a retainer is unfair. Secondly, you need to think about whether or not the client is provided with enough information from you to make an informed decision. Please don't get confused with arguments about Belzner and Camp and fiduciary duties, namely informed consent. That's a different thing. This is whether or not you give the client enough information to make an informed decision. In other words, to make a valid agreement to bring into effect the solicitor and client presumptions of reasonable incurrence of costs. And the third theme is no surprises. And that comes from the Ombudsman's view of good cost service, updated most recently to the third edition in November of 2023, where the Ombudsman writes this: a client should never be surprised by the bill they receive from their lawyer. So if you make sure that every step you take is guided by an attempt to ensure consumer protection, to ensure that all decisions made are informed, and to ensure that when the client gets that bill, there are no surprises, then you will have a very good and firm rudder following the direction of travel of legal thinking at the moment.
And I agree with that. We'll look for some points of discord later in this talk. There will be some, I'm sure. But I think both Matthew and I take the view that the direction of travel is clear. And if you consider the recent decision of the Supreme Court, Oakwood Solicitors and Menzies, which Erica and Craig talked about, I think, last week, then that decision, again, can be is explicable as a consumer rights protection measure. In particular terms, in that case, ensuring that the client has the opportunity to consider a bill, agree a bill, or not agree a bill, as the case may be, and then, and only then, will there be sign-off in terms of the limitation provisions which apply to solicitor and client cost assessment. I think we don't want to spend too much time on Oakwood because Craig and Erica have, of course, dealt with that very fully. But Matthew, you mentioned the Belzner and Cam legal services case. And I think it's a very interesting case just to revisit briefly, because I think there are a couple of points that I would draw from it. At the time, it was seen as a notable success for the solicitor's profession. And in a very real sense, it is a success for the solicitor's profession because it drew out of scope many of what might otherwise have been very small disputes, but nonetheless high court costs claims in respect of success fees and similar charges made in low-value personal injury cases. But it wasn't the case that the Court of Appeal was saying that no such claim should ever be brought. One of the more significant parts of the Court of Appeal's decision was that these matters should quite properly be referred to the legal ombudsman rather than to the High Court or district registries of the High Court. And often, of course, the legal ombudsman can give a more effective remedy than a cost judge can. Just to make a single point on that, it's often said that the legal ombudsman is not bound by law. Now, that doesn't quite mean what it might appear to mean. It's not the case that he can take solicitors out the back and shoot them. What it means is that the scope of review is perhaps wider than looking at reasonableness or consent or matters of that nature. You get factors such as good client care and transparency being woven into the mix before the ombudsman comes up with a remedy which suits the problem as he or she sees it. Any thoughts on the direction of travel regarding the legal ombudsman, Matthew, and whether we're likely to see more involvement by the ombudsman service in this sort of area?
Well, actually, it's encouraging. It's encouraging provided you do the donkey work. The legal ombudsman will be on your side provided those three things that I've referred to as general themes have been adhered to. And most importantly, if the ombudsman is satisfied that you have given enough information to the client for the client to make an informed decision, and if that bill ought to come as no surprise to the client, then the ombudsman will say to the client, That's what you signed up for. The Ombudsman's got a very heavy workload and just really wants to see those two boxes ticked. Before you think, though, that all of this can be reduced to a written retainer, be very careful, because in Belsner, the Master of the Rolls discounted the notion of informed consent playing a part. It would be an easy mistake to make that the Master of the Rolls was somehow saying the need for an informed decision to agree to any form of a retainer is not required. That's very clearly not what he was saying. What he was talking about was quite specific, and that was whether or not there had been informed consent to deviate from or to release a solicitor from a fiduciary duty. That simply, on the circumstances of the case, didn't apply. Now, given that you need to have informed decisions, given the complexities of many retainers, and given that many clients will only use a solicitor once, it seems to me that that is going to involve, whether you like it or not, more human engagement with the client. In days when there used to be one solicitor with one file and one client and meetings, that wouldn't be too difficult. These days, where you have many fee earners dealing with a file, and often, certainly, lower value work is treated as a commodity, there can be very little communication with a client. But that needn't be the case. In these days of Teams communication and FaceTime, there is no reason, or WhatsApp, there is no reason why you can't chat very readily and very easily to a client for a very short period of time, often more quickly than you would be able to prepare a letter. And that need for human interaction occurs at the beginning and the end, because there is one thing that Lord Hamblin said in Oakwood that really does put the brakes on the ability simply to write into a retainer something that deals with the issue of settlement of account and payment of the bill. So my view is, again, that's a matter for human engagement, because at paragraph 43, Lord Hamblin said this: client protection is diminished if payment occurs before there's any opportunity to consider the bill of costs and whether, and if so, to what extent it should be paid. Now, the best way of giving the client that opportunity is to talk through the bill with the client. Might sound naive of me to say that that's the gold standard, but it clearly is. The Ombudsman will therefore be looking for, I think, not just the informed agreement to terms and also the lack of surprises, but also that human element.
I think that's a really interesting point, Matthew. Before we go on to develop the next theme, I think that just two observations that I would add myself. The first relates to the fact that there is the way that the law is meant to operate, and then there is the way that the law does operate in practice. And what you can see is that there's often a disjunct between the two. And this can be particularly the case in relation to costs. So let me give two examples. Part of my work, and I suspect part of the work of many people on this call, involves dealing with costs in cases where there have been insurance companies on the other side indemnifying a party to the litigation. Often their arrangements will be that the litigation is dealt with by one firm, and then the costs are dealt with by another firm. And that's all fine and dandy as far as it goes, but it can mean that the second firm dealing with the costs find to their horror that something has been agreed by the first firm, who had no idea that what they were doing would create a particular problem in relation to costs. And why should they? Because their remit ends at the point of settlement. If you look at it from the other end of the lens, it's often the case when you have people bringing consumer disputes or personal injury claims or something of that nature, that the litigation will be sorted out, a settlement agreed, an agreement in principle reached in relation to costs, and then the issue of the costs goes off to the cost department, or even be outsourced to independent cost lawyers or cost draftsmen. But that is the point where you could find problems arising, because the relationship, the client care that has been carefully nurtured over 2 or 3 years, or maybe even more, has suddenly come to an end because you have a fresh team of lawyers being embarked upon what's seen as the second part of the case, when it's actually no such thing. As far as the client is concerned, it's simply the continuation of the same case. But you then have this problem where the system deployed by solicitors means that you can easily get a client who slips through the cracks of client care. So those are our opening thoughts. What I'd like to do now is delve down a little bit more into another general theme, which is informed consent. And Matthew, I think, has opened this beautifully in terms of the significance of it, importance for such factors as transparency. But if we drill down into 2 areas of black letter law effectively, one of the intriguing points in Belsner, which I don't think has been resolved, is that it's been established clearly that when a solicitor is negotiating a retainer with the client, they don't owe a fiduciary duty. But Belsner may be said to have nothing to say about what happens when you are established as someone's client and then need to revise or alter the retainer. Is there scope then for a fiduciary duty to arise in circumstances where the client may effectively be locked into a piece of litigation, or has spent all their money, or be in a position where they're more vulnerable than they were at the beginning of a matter when the client was being retained and therefore had far more scope to negotiate a bargain? That, I think, is the point which may very well be developed in the case law in the next couple of years. The other point that struck me was that all of these retainers have to be written with an eye to the potentiality of a solicitor-client cost assessment, a dispute arising, in which case can you foreshadow the engagement of the presumptions contained in Part 46.9 of the Civil Procedure Rules, and in particular to what extent do you have to do so. It's always best to give a tangible example. If you're claiming very high hourly rates, higher than the rates which the court would allow, then it could be said that these rates are going to be a species of unusual costs. Therefore, to be able to recover them as against your own client, where there'll be an inevitable shortfall on the monies recovered from the opponent's litigation, you should really be getting the client's consent to these hourly rates through providing an explanation to them so that you tick the box of informed consent. And it can be seen, therefore, that this might be a matter which has to be included in the retainer at the outset, if, for example, you're going to claim hourly rates. But if I kick the ball over to you, Matthew, where do you think we're going with this more granular approach to informed consent?
Well, there are 2 stages. At the first stage, when you are not in a fiduciary position, when you're negotiating the retainer, you still need to have the client in a sufficiently well-informed position to make an informed decision. And that comes from McDougall and Boot Edgar Estikin, a case from 2001, a High Court appeal. Because if there is a solicitor and client dispute, you're going to want to be able to argue under CPR 46.9, 3, that the costs have been reasonably incurred because they were incurred with the express or implied approval of the client. And McDougall and Boot Edgar Estikin, which was an argument about hourly rates, Mr. Justice Holland said this: to rely on the applicants, who were the clients in this case, to rely on the applicant's approval, the solicitor must satisfy me that it, namely the hourly rate, was secured following a full and fair exposition of the factors relevant to it, so that the clients, laypersons as they are, can reasonably be bound by it. So that's stage 1. Once you've actually concluded the retainer, things get very difficult indeed, as Andrew's just indicated they might, because there's no binding authority on what's going to happen. But you can imagine that some very difficult arguments would arise once the solicitor is in the position of a fiduciary. And all you need to do to spot that difficulty is look at paragraph 72 of Belsner, where the qualities of what leads to somebody being a fiduciary were spelt out by Lord Justice Millett in a case called Mothew. And I'll just paraphrase part of the indented quotation that you'll find. The distinguishing obligation of a fiduciary is the obligation of loyalty. The principal is entitled to the single-minded loyalty of his fiduciary, must act in good faith, mustn't make a profit out of his trust, must not place himself in a position where his duty and his interest may conflict. So, you've got a retainer with your client. You're now a fiduciary. You do owe that duty of loyalty. You spot that you've got a retainer which has enforcement difficulties so that your client is in a position whereby it may be that subsequently it can be argued that the client is entitled to those services without charge. And yet you want to say to your client, I want to repair that retainer so that you can be charged. In other words, you, in that position of loyalty, are now going to turn around to your client and put your client at a less advantageous situation than he presently stands in. It seems to me that's why, as I said at the outset, if you do need to repair a retainer, you have to be open about the reasons for it with the client, for it with your client. And it may be that your best option is to repair it in such a way that the client is rendered harmless, classically, as I said, by way of a CFA light.
Well, the ice has broken, and we've now got a couple of questions bubbling up in the chat box. And the first one is a question: what is a statute bill and what is the significance of a lawyer's signature on a bill? Well, I'm pleased to tell you there's no such thing as a statute bill. There is a statutory bill, as we were told by the Master of the Rolls in the Belsner case. So the terminology has changed, but the significance of a statutory bill remains. And it's simply this. If a solicitor wants to sue their client for their fees, they have to deliver a statutory bill to the client. That bill has to satisfy all the requirements contained in the Solicitors Act of 1974 to be a valid bill, and one of those is that it is signed. It can be an electronic signature as opposed to a wet signature. It can be in a letter accompanying an invoice, but without a signature, no bill, therefore no ability to sue a client. Now, there's also another question which has arisen in the chat box, Matthew, which relates to this issue of a potential discounted conditional fee agreement. I know you were looking at that earlier. Do you want to field that one?
Yes, of course. It's not unusual for defendants to have differential fee agreements, whether they're funded by insurance or not. The question is this: there's a construction dispute, and the defendants have a budget which allows them and is calculated on £250 an hour. And the defendant has been quite open with the claimant and has said that if there is a loss for the defendants, I don't know why the defendants have said this, but if there's a loss, they will charge at a discounted rate, and they will charge £120 plus VAT per hour. Now, 2 times 120 is 240, which is less than the total, and therefore it gives rise to the issue of whether or not a success fee of more than 100% is being charged. The answer, in my view, is that probably not, at least quite possibly not, because a discounted CFA is not at all unusual. This could be a discounted CFA where there's no success fee at all, where the base hourly rate being charged is the normal hourly rate, is £250, which sounds normal for a construction dispute. In fact, it sounds quite cheap. I suppose it depends on the size of the dispute. But only £120 is to be paid in the event of a loss. As long as that agreement's in writing, there is no problem, because in a case called Gloucestershire County Council against Evans in 2008, the Court of Appeal said that you look at any success fee by comparing it against the normal fee. In other words, the fee that will be charged before discount. So in this case, theoretically, if there were a success fee, the solicitors could charge, in the event of a win, the defendant, £250 an hour, plus a success fee of another £250 an hour. But the person who asked that question is very wise to be alive to the issue, because sometimes large defence solicitors acting for large insurers or institutions may once upon a time have had careful retainers, but with the regularity of practice, with the familiarity of practice, everybody thinks that there's a usual retainer in place, but there is such familiarity that there can be errors made and they aren't put in place for a particular case. So my inclination is that it's not likely to be a problem, but you should be alive to persist in asking questions. Who knows? Maybe they'll satisfy you that it is a discounted CFA.
There's just one more question I'll sweep up before we move on to our next topic, where it was said, if the client doesn't speak adequate English, do you need a translator to explain the CFA? And the short answer is yes. If you sign a document that you can't read, you are bound by it. But I see no circumstances in which you can get any informed consent on, for example, the hourly rates if someone doesn't really understand what they've signed. And it seems to me that as part of client care, if you're going to deal with people who don't have a good command of English, then you need to take that into the way you organise your firm. So let's move on, because time is ticking away, and we wanted to talk about how you structure a retainer. And in my view, the perfect retainer is less than 2,000 words in length. I imagine a lot of people listening to that will think, well, how on earth can we achieve that? And if you look at your own standard form retainers, I suspect they go on for folio after folio. There's probably a client care letter. There's probably a funding agreement, such as a CFA or a DBA, and there are probably terms of business knocking around as well. I would also suggest that those documents may be of some antiquity, and as the years have gone by, they have been added to, but no one has ever taken away any paragraphs from them, and you're in a position where there may be multiple provisions which conflict with each other, all making for something of a bit of a mess. So when we consider the case law on this, Jones and Wrexham Borough Council is clear authority that a court, when construing a solicitor's retainer, will look at the package. So it's not just, for example, the conditional fee agreement, it's also going to be the client care letter, which often will be something additional to or explanatory of the conditional fee agreement. And therefore, all these documents have to be very carefully drafted, interwoven and interlocked, so that they're saying saying effectively the same thing, or what you want them to say, whichever way you look at them. Any thoughts on structuring a retainer, Matthew?
I'd only add this, and there is some difficulty with a retainer being succinct, because it's almost as if you're damned if you do and damned if you don't. If you include every conceivable possibility in the retainer, and if you deal explicitly with all of the regulations and all of the twists and turns, and in this regard, I would strongly commend that you go through chapter 28 of Friston on costs, where he sets out all of the regulations that you need to comply with. And certain of them, for example, the cancellation regulations, the additional charges regulations of 2013, I always take the view that it's probably unsafe to have in a standard form retainer some sort of delete if appropriate approach to whether or not it's an on-premises or off-premises contract. The view I take is it's far safer, and I know some solicitors agree with me, that the best thing to do is just provide the information that the schedules say that you provide in their entirety for every retainer, and give the client cancellation rights with the cancellation notice for every retainer. And then no solicitor can fall foul by not providing the information. Once you've done that, you're going to have a document of quite some length. You're going to have to work quite hard, it seems to me, to make that succinct. The goal has to be to try and make it as succinct as you can. And I entirely agree with Andrew that less can be more, but I can understand why your heart will be in your mouth when you're trying to achieve it. And it seems to me that there are ways that you can make things easier for the client. And I go back to the human element. It is difficult to have some informed understanding of the documents you send to your client without some sort of meeting. And if you telephone your insurer and you provide information for the purposes of a quotation, that information will be recorded. If you make your proposal for insurance online, that information will be recorded. There can be nothing better than a brief, and it doesn't have to be that long, a brief meeting with the client talking through the main terms of the retainer. You can explain to your client that it's going to be recorded, but you should certainly have, at the very least, some sort of declaration with your client that is understood, that those headline points are understood. Perhaps most importantly is, so far as structuring a retainer is concerned, most importantly, it's important to scotch the idea that a retainer can be standard form in all cases. You need to have a very clear understanding of what you're doing. In bulk cases that are worth tiny amounts of money, then it simply isn't going to be viable to have carefully bespoken retainers in each case. However, if you are looking ahead at possibly having to charge your client hundreds of thousands of pounds, maybe $1 million or more in relation to costs, then it would be money very well spent to spend half a day going through your retainer, your terms of business, and then carefully preparing a client care letter explaining those to the client, being careful to state that the written retainer will take priority in the event of conflict of any of the other documents, because that half a day will be money very well spent, and you could very well regret 3 or 4 years down the line not having spent that time. One of the biggest mistakes that I think both of our clients probably make, and I think I'm probably safe in assuming that Andrew will agree with me, is that solicitors too often only think about the retainer after the work's been completed.
I would concur, Matthew, because you and I have both been in situations arguing against each other about retainer problems which have arisen on a case where fundamentally the solicitor's done a very good job, got a result for the client, now wants to be paid, but then issues have arisen over the retainer and the whole issue is thrown into doubt. I think also it shows, doesn't it, a sort of human vulnerability when drafting a retainer. And I put it this way: if a solicitor's asked to draft a contract covering several £100,000 worth of money, effectively, then that contract will probably go through multiple drafts and redrafts. There'll be meetings with the client, and then the contract will be signed off as a finished piece of work. So why should a solicitor devote any less time when it's his or her own fees at stake and they're in charge of drafting that contract? Just had a quick query in from Caroline, which I'll deal with now, who says, well, when you review your hourly rates in the contract, do you think this should be a general provision, or should it give more information, say linking increases to inflation or SCCO guideline rates? I think if one unpicks that and steps back, then virtually every CFA will have provision that hourly rates will be reviewed in January or April or some other month of each year, and some will go into more detail than others. But it seems to me that if you have such a clause which doesn't have set criteria, it's not open to a solicitor to say, well, I'm charging £250 this year. I'm going to increase that to £500 for next year because, quite frankly, I think I'm worth it. You can't do that, because implied into that obligation will be an obligation to act reasonably or at least rationally. And so all you're doing by putting in a criteria such as inflation, and there are at least 3 measures I can think of you could use, or SCCO guideline rates, is you're just expressing what will be factors that a judge would look at anyway when thinking how the implied provision for reasonableness or rationality will relate. Gosh, time is advancing, isn't it? It's already 25 to 5.
It is. I hope you'll forgive me, but I think there's something really important to add here, and I think it goes to the surprises point. First of all, if you think that you'll want to charge by hourly rate, and if you believe that this is a case that's going to last long enough where those rates are going to increase, then you must tell your client that they're going to increase. And you will know, because of the business you work in, what factors will be relied on for that increase. And you have to tell the client what they are. If it's just general inflation, then so be it. If it's because you're planning incurring certain debts as a business and therefore you'll need to generate more profit, then you'll need to say that. But when I spoke about sitting down, and it's not dead time, this half a day reviewing the retainer at the beginning is not dead time. In order to avoid surprises, you are going to have to tell the client what the costs are going to be, how they're going to increase, what they're likely to recover, what they're going to be expected to pay by way of shortfall. And if you take all of that to its logical conclusion, if you are wedded to the idea of charging by way of hourly rate, it's very difficult, and you only need to posit those things to yourself and be honest with yourself. It's very difficult to resist the notion that a budget between solicitor and client almost becomes mandatory.
Yeah, and that has featured in the case law, particularly in relation to the deductions cases. Let me just round off this point before we move on to particular types of retainers. We're sending out slides after the seminar, so you've got references for all the case law and documents we mentioned. There are 3 particular Law Society publications that are worth looking at: Engaging Client's Guide, the Client Information Requirements, and the Information Obligations for Service Providers. None of them are exactly stimulating reading, but they do provide a useful body of thought as to what needs to go into retainers, or what are mandatory requirements to put in particular in relation to such things as details of how people complain about you. So let's move on, because we wanted to look at non-contentious business agreements first of all. And it's important to note that these aren't damages-based agreements because they relate to non-contentious work. And they're provided for in the Solicitors Act of 1974, Section 57. And they provide that in practical terms, I say this with a degree of flippancy, anything goes in terms of how you structure the payment for your retainer. So you might charge an hourly rate, but you can also charge a commission or a percentage. And what that means is that if you're dealing with work which most of the public will regard as contentious, but the law doesn't regard as contentious because it's not litigation or arbitration proceedings, you can use them to run cases. So I see them used in criminal injuries cases. I see them used in financial mis-selling cases where people are applying for redress under various schemes or to Ombudsman. And they can also be used as a part of a hybrid retainer. And by that, what I mean is this. It seems quite conceivable and logical that what you could do is you could structure your retainer that if you settle a case before the point of issue, the client is charged on a non-contentious basis, which could be a percentage payment or whatever. But you could also provide that if you have to issue the case and the parties agree that immediately before issue, that non-contentious business agreement is rescinded and of no effect, and what you put in place is something like a conditional fee agreement, which would be apt to cover a litigated case because that is contentious business. That introduces complexity in the drafting, but it seems to me conceptually that it's not problematic. But what do you think, Matthew?
I think the difficulties here are practical. It can be drafted. There are drafts available by people who provide them. But imagine this. If you keep in mind the three themes that certainly I started with, and that of the Ombudsman and the Ombudsman's anxiety to ensure that the client is not surprised, then imagine how a hybrid retainer might work. Forgive my language, but up until issue of proceedings, the fee will be a cut of the recovery. After issue of proceedings, assuming that fixed recoverable costs don't apply, but just to keep it simple, after issue of proceedings, costs will be calculated on an hourly rate basis. What if, and it's again conceptually possible, what if the cut that you would be demanding from your client days before issue is more money than you would be charging your client on an hourly rate basis after issue? It seems to me that these sort of possibilities are things that would need thinking through very carefully by you. And then, if you thought that it were an acceptable way of proceeding, you would need very carefully to explain them to your client so as to avoid the accusation or the protestation by the client that he or she had been surprised by the bill.
They're such ungrateful creatures, but we can't live without them. And I agree, Matthew. It can be done, drafting, but you've got to be very careful and think about how you're going to operate this in practice. We'll move on, as time is ticking, to conditional fee agreements. And it's funny, isn't it, that conditional fee agreements have been enshrined in the legislation for 34 years now. Courts and Legal Services Act of 1990 effectively overturned 700 years of common law with prohibitions against the use of contingency fees in litigation. But in a sense, it's the gift that never stops giving, because there are always new points in relation to conditional fee agreements. The structure remains, however, that set out in the 1990 Act. You look at sections 58 and 58A and the regulations made under that, which are now the Conditional Fee Agreements Order of 2013. I think that in terms of the issues that commonly arise, what I put on my shopping list are the treatment of success fees, because it still happens from time to time that people breach the requirements on success fees. One is by charging a success fee which isn't expressed as a percentage. Another is that they charge more than 100%, or another is that they charge a percentage of the damages rather than an uplift on the costs. The former is going to make the agreement unenforceable. The latter is the way that it has to be done. In terms of scope, I see cases where people exclude a counterclaim from their conditional fee agreement, but then one bobs up in the proceedings, and they may find themselves going forward without a retainer unless the point is missed. We have this problem of fixed costs now applying to money claims up to £100,000, but of course solicitors still wanting to work on an hourly rate basis. And then of course there's a small hand grenade being thrown into the whole business recently by the issues of interim statutory billing when you're working on a discounted CFA, and to whether in fact you can, or conceptually at least, have an interim statute bill where a discounted CFA exists. But those were the thoughts I had, and let me again pass the baton over to Matthew to set out what he'd like to say.
I suppose three things, really. First of all, the first thing is it is now important to be very clear in a retainer how you're going to charge when the recovery between the parties is going to be fixed costs. If you're going to charge your client an hourly rate, irrespective of the fixed costs, then it might be, it's conceptually or conceivable that the fixed costs on occasions will be more and on occasions will be less. And if you're charging by hourly rate, if they're more, of course, those fixed costs won't be yours. They'll be the client's. Most solicitors that I've come across are doing the opposite, in that they are saying that if fixed costs apply, and if fixed costs are more than we have accrued by way of hourly rate, then your liability to pay us is those fixed costs. It's important for two reasons, because Table S1 in the intermediate track of fixed recoverable costs is not a fixed cost, it's a capped cost. So in your retainer, you have to have some method of the costs accruing if it falls into that category of costs so that they can be measured, so you can tell the court what they are. It's also very important because of Section 74.3 of the Solicitors Act and CPR 46.92. If the costs are fixed in contentious business in the county court, then the upshot is that you have to have an express written agreement from the client that you are able to charge the client, and the client agrees to pay more than those fixed recoverable costs. That's the first point. The second point is, and all the legal press has been alive to the case of Ivanishvili, and you can't render statute bills for a CFA. Hopefully, when that case came out, you all thought that that's just a confirmation of common sense. Mark Friston has been saying that in his book almost since it was published, and it's difficult to see how you could possibly have a statute bill before the right to payment has crystallized when you've got a CFA. So that's the second point. And the third point, and it drives me mad, because there are lots and lots of lawyers who try to be cleverer than the legislature. And I understand it comes from a good point, that they're trying to make legislative words more comprehensible for the client. But on things like the success fee, it's very dangerous not simply to parrot verbatim the words of the CFA order of 2013. In other words, we charge you in proceedings at first instance as a success fee no more than 25% of general damages for pain, suffering and loss of immunity, and damages for pecuniary loss other than future pecuniary loss, net of any sums recoverable by the Compensation Recovery Unit of the Department for Work and Pensions. I've got it in front of me. I always have it in front of me. I never deviate from those words. And on countless occasions, I have to tell the client, the solicitor client, that, again, forgive my language, that it's squeaky bum time, because the CFA says, we promise not to take more than 25% of your damages by way of a success fee. They're trying to make it easy. They're actually making it very dangerous.
I think that's right. And that brings you into the sort of mismatch between the client care letter and the CFA and what is actually being agreed. And you just don't want that argument. We've had a couple of questions, which I think we'll just sweep up now. One of the questions is there a need to obtain instructions on costs offers from the client and authority before settlement of cost? The answer is yes, but then that has always been the case. Costs don't belong to you. They belong to the client, and you must therefore obtain express authority from the client before you do anything in relation to the client money. That follows on from another point, which I think Matthew mentioned earlier, which is the involvement of the client in cost budgeting. Cost budgeting is not a dirty little secret to keep from the client. The client needs to be given the budget, explain to them what its significance is, and then they need to be given the amended budget after a costs and case management hearing to see whether they agree that you should continue to incur the costs which the judge has trimmed out of the budget. Because otherwise, the danger is that those costs will be treated as unusual costs at the end of the case and not recoverable from the client, let alone the other side. Well, we're now into the last 10 minutes, and I wanted to talk about damages-based agreements. And perhaps, Matthew, if we take this and litigation funding together, as I think they fit naturally. With damages-based agreements, I'm not sure how many firms or solicitors use them, because some use them quite a lot and others wouldn't touch them with a barge pole. But they're the innovation brought in 2013 by amendment to Section 58AA of the Courts and Legal Services Act. They have their own statutory regulations, the damages-based agreements regulations of 2013, and they borrow from a model in Canada whereby you charge a client a percentage of the damages that you recover, but in circumstances where you still recover costs, but have to net off those costs from the payment that you've agreed with the client. There are a lot of issues still, 10 years on, about damages-based agreements. The potential for upside is obviously huge if you have the right case, but there are still very fundamental points outstanding, such as, for example, whether you can have a damages-based agreement between solicitor and counsel. With litigation funding agreements, many of you will be aware of the Packard case of 2023, where the Supreme Court found that if you make a litigation funding agreement with a client, which provides for you to recover a share of the damages as payment for the litigation funding, that will actually constitute a damages-based agreement. Almost inevitably, that will then fall foul of the damages-based agreements regulations of 2013, because litigation funding agreements were never intended to comply with them. And all those problems that ensue about potentially unenforceable agreements were meant to be addressed by the Litigation Funding Agreements Enforceability Bill, which the former Conservative government brought forward in the spring. But a lot has happened since then, and one of the things that has happened is that bill was lost when the election was called. What I'm keeping an eye on is the developments in the Competition Appeal Tribunal, which is acting as the forge or crucible where issues about enforceability of agreements and DBAs is probably being hammered out case by case. But Matthew, what are your thoughts on damages-based agreements?
I really don't like them. And the reason I really don't like them is a practical one, really. Litigation, if it's proper, if you're dealing with commoditized work and you have a huge basket and you know that simply taking 25% from every claim and you can comply with the regulations, then that's not a problem. In a bigger case, it's a nightmare because you have to sell to the client that you're possibly taking a cut of the damages after the very first letter. And that's not necessarily a bad thing, because the client gets a very understandable agreement, but also gets an understanding that if the case goes through to trial, that same cut will be taken in the event of a win. Now, who in a large case would be prepared to say, I will take a cut of the damages in respect of something that I've been working on for 4 or 5 years and goes to a 10-day trial? Things can happen along the way that mean that what you expected to be a £1.5 million or a £10 million claim turns out to be a £50,000 or a nominal damages claim. So if I were in business, unless I had that basket where I could balance out my averages, I wouldn't want to go anywhere near them. And that's got nothing to do with legal compliance. That's just practicality.
And they're nasty things to draft as well, aren't they?
Oh, yes.
I think we're into the last 5 minutes, so let's sweep up the last couple of topics. One of which is the solicitor's account rules. And I think that has now become front and centre, because if you're looking for ways to deal with the Oakwood decision, then part of the answer, at least, is in the way you deal with the billing of the client and the way that you move money around in accordance with the solicitor's accounts rules. But that's really important to know what they are. And a lot of solicitors haven't looked at them since the LPC. Two rules which I think are particularly worth attention are the Rule 2.5, which means that you can't hold on to client money forever. But of course, that raises the issue as to what you can hold on to by way of retention, lien, if you like, in respect of your fees. And the second one is the requirement that when you move money out of the client account to pay your fees, you have to give the client a bill or written notification, but in either case for the precise amount you're moving. And a written notification will function as a request for payment on account. So that could ease your cash flow problems, with, of course, a final reconciliation at the end, and everybody knows where the inter partes costs are, as well as making the solicitor-client charge by way of a final statutory bill. In terms of current issues in drafting, I think that there are a number of points that we've already discussed, others which we'll deal with now. One of the issues that I think has to be grasped in CFAs going forward is that it's an hourly rate model, but in a fixed cost world. And so the terms that need to be put in need to deal with the ramifications of that. We've already touched upon the need to obtain informed consent on such things as shortfalls in hourly rates that can be reasonably anticipated. And either the CFA itself or the client care letter, or possibly both, need to deal with that. Menzies we've had a look at. And one of the interesting points, which I don't think we've really got time to develop, is what scope there is for hybrid DBAs. Because, of course, we know from the majority decision of the Court of Appeal in the Zuberi case that the DBA is only the tiny little bit which deals with payment in the event of a win. It's possible, I say possible deliberately, that if you lose a case, you may still be able to charge the client a normal hourly rate to make it function more akin to the effect of a discounted CFA. But these are all issues which, notwithstanding the decades that have passed since this legislation took place, remain very much up in the air. But what are your thoughts, Matthew?
Well, funnily enough, turning it on its head, current issues in drafting, I like to see perhaps the other way. In this sense, there are, in my view, current issues that cannot be resolved by drafting, not safely so. Take, for example, you'll remember what I said about Oakwood and Menzies at the beginning, about client care being imperiled if the client doesn't get to see the bill before being asked whether or not he agrees to pay it. At paragraph 79 in Menzies, this is said: there's no reason why there can't be a prospective agreement as to some or all of the costs to be charged. It can be done by agreeing a fixed fee or by fixing costs through a mathematical formula. So the Supreme Court says, well, actually, you could agree payment in advance if you had some sort of formula. But that in itself, if anybody seizes on that and thinks, there's a way to draft it, it just lands you in more problems, it seems to me, because if you have a clear formula like that, then somebody's going to say, well, that's a contentious business agreement, because that's what a contentious business agreement historically always is, a clearer way of agreeing costs for a piece of work. And all you need to do is then go to section 61.5 of the Solicitors Act, and that provides for an assessment in certain circumstances, if there are special circumstances, beyond 12 months after payment. So you end up with the same problem that you started with, that the client can still have an assessment. It's not an issue that was spoken about in Oakwood and Menzies. It wasn't argued about, but it just goes to show how what you think could be clever drafting won't get you there. What you really need to do is get a bespoken placing of the bill before the client, a particular conversation in some way, whether it's by email, by letter, or by video call with the client, and you need approval of that bill. And you might as well front it up. You might as well say to your client, can we agree or can't we agree? Because if we can't agree, you're going to have an assessment. And it seems to me that you're being given very little room for maneuver outside of that. You might as well face it, and the people for whom it presents nightmares are the people who turn over thousands and thousands and thousands of smaller files, for whom a conversation with the client is a nightmare. And I'm sorry about that, but there just isn't an easy drafting way to get around it.
I think that must be right. And I think we're now in our last minute. And so I'd like to, as my final word, just sort of step back and say, it's easy to get lost in the thickets of the law relating to retainers, but fundamentally it's actually very simple. You need to deploy some empathy and emotional intelligence and ask yourself, are you treating the client fairly, or are you creating a rod for your own back by giving the client something to complain about? And every solicitor-client cost dispute fundamentally comes down to this: a failure in client care, a breakdown in the client relationship. And if you take proactive steps to manage the client, then your solicitor-client cost disputes are going to be very far and few between. What about you, Matthew? What would be your concluding thoughts?
Well, for my closing words, in showing empathy and in demonstrating some client care, I sincerely apologize that we can't answer all of the questions that are there. There's one I spotted that I didn't answer, and I suppose it shows generosity of spirit in promoting a competitor. But he is a former colleague of ours. Mark Friston's book was the one I mentioned, and somebody asked what the book is and what the title is. I hope you can see that. It's Friston on Costs, 4th edition, published by Sweet and Maxwell, or is it, Oxford University Press. But for my part, thank you.
I think that's excellent. It is a truly tremendous work of scholarship. Now, we've reached the end. Well, it's time to say, I think, Happy Christmas, and we wish you a peaceful new year. But it's goodbye from me.
Yes, thank you, everybody. Bye-bye.